Mary, a duly commissioned notary public in New York, decides to help a friend by preparing a deed transferring real property to that friend for a fee, even though Mary is not an attorney. Mary also alters the official record of a previously filed mortgage discharge, changing the date to deceive a lender. For a routine affidavit, Mary charges 3 times the legally permitted notarial fee. Finally, Mary never took or filed her required oath of office before performing any notarial acts. Which of the following statements are accurate under the laws provided? 1. Preparing a deed for another person and charging a fee without being admitted as an attorney constitutes the unauthorized practice of law. 2. Altering a recorded legal instrument such as a mortgage discharge with the intent to deceive is forgery in the second degree, a Class D felony. 3. Charging more than the statutory fee for administering an oath can subject the notary to treble damages in a civil action. 4. Performing notarial acts without having taken and filed a required oath of office is a misdemeanor. 5. Engaging in unauthorized acts as a public officer to benefit oneself constitutes official misconduct, a Class A misdemeanor. Well, let's have a look at each of these statements in isolation as compared to the relevant law to help us determine which of these following statements, if any, are accurate. So once again, statement 1. Preparing a deed for another person and charging a fee without being admitted as an attorney constitutes the unauthorized practice of law. Well, if we have a look at the judiciary law section of the Notary Public License Law booklet, and in particular section 484 entitled None But Attorneys to Practice in the State, I am not going to read from it, but it makes it clear that only licensed attorneys can practice law, whereas notaries public who are not licensed attorneys are not allowed to practice law, and if they do so, then that constitutes an unauthorized practice of law. And it does give various examples such as preparing deeds, mortgages, assignments, discharges, etc. So clearly this covers the facts in this question, and therefore statement 1 is indeed an accurate statement, and we can put a check mark next to it. 2. Altering a recorded legal instrument such as a mortgage discharge with the intent to deceive is forgery in the second degree, a Class D felony. Well, if we have a look at section 170.10 found in the Notary Public License Law booklet entitled Forgery in the Second Degree, it states, a person is guilty of forgery in the second degree when, with intent to defraud, deceive, or injure another, he falsely makes, completes, or alters a written instrument which is or purports to be or which is calculated to become or to represent if completed 1. A deed, will, codicil, contract, assignment, commercial instrument, or other instrument, and this is clear here because this does refer to a discharge, or other instrument which does or may evidence, create, transfer, terminate, or otherwise affect a legal right, interest, obligation, or status. And if we jump to the bottom, forgery in the second degree is a Class D felony. So indeed, statement 2 is an accurate statement based on this law that I just read from, and therefore we can put a check mark next to statement 2 as well. 3. Charging more than the statutory fee for administering an oath can subject the notary to treble damages in a civil action. Well, if we have a look at section 67 found in the Notary Public License Law booklet entitled Fees of Public Officers, it states at subsection 2, an officer or other person to whom a fee or other compensation is allowed by law for any service shall not charge or receive a greater fee or reward for that service than is so allowed. And then 4, an officer or other person who violates either of the provisions contained in this section is liable, in addition to the punishment prescribed by law for the criminal offense, to an action in behalf of the person aggrieved in which the plaintiff is entitled to treble damages. Therefore, as we see, statement 3 is also an accurate statement, and we can put a check mark next to it as well. 4. Performing notarial acts without having taken and filed the required oath of office is a misdemeanor. If we have a look at the Public Officers Law section of the Notary Public License Law booklet, it states, notary must not act before taking and filing oath of office. The Public Officers Law section 15 provides that a person who executes any of the functions of a public office without having taken and duly filed the required oath of office, as prescribed by law, is guilty of a misdemeanor, and it makes it clear a notary public is a public officer. Therefore, based on this law, statement 4 is accurate as well. We can put a check mark next to 4. And finally, statement 5, engaging in unauthorized acts as a public officer to benefit oneself constitutes official misconduct, a Class A misdemeanor. Well, if we have a look at section 195 found in the Notary Public License Law booklet entitled Official Misconduct, it states, a public servant is guilty of official misconduct when, with intent to obtain a benefit or to injure or deprive another person of a benefit, 1. He commits an act relating to his office but constituting an unauthorized exercise of his official functions, knowing that such act is unauthorized. Official misconduct is a Class A misdemeanor. So indeed, statement 5 is also accurate, and we could put a check mark next to statement 5. With all this in mind, let's have a look at the 4 choices to determine the solution. Again, we're looking for which of the following statements are accurate, and we've listed all 5 statements as being accurate. Choice A states 1, 2, 3, and 4 only. This is incorrect because 5 is also accurate, therefore choice A is not our solution. Choice B states 1, 2, 3, and 5 only. This is incorrect because 4 is also accurate, and therefore choice B is not our solution either. Choice C states 1, 3, 4, and 5 only. This is also not correct because 2 is also accurate, and therefore choice C is not our solution, which leaves by process of elimination choice D, but let's have a look to be sure. Choice D states all of the above. Well, based on what I checked off before, this is correct, and therefore choice D, all of the above, is the correct solution.